ladies and gentlemen around the Delaware Valley. Welcome to the McMenamin Wing Show here on WWBD Talk 860. I'm your co-host, Joe Dougherty, with Tom Wing, our co-host. How are you, sir?
I'm doing fantastic. I'm excited for the show today.
Well, I can tell you this. I do something with the labor community called the Legends of Labor, right? And we honor different, legends in the industry. Well, this show should be called the Legends of Legal and Workers' Compensation, because you got one of my favorite people that I've ever met since I've been in this business, and certainly somebody who revolutionized workers' compensation and changed so many lives in the process. So, Jay Shor, welcome to the broadcast, my friend.
Thank you, Joe. It's a pleasure to be here with you and Tom.
Well, I can tell you, I was so excited. Soon as Tom told me you were going to be on the broadcast, I was, I guess he told you. But, when I think of Jay Shor, I think of integrity, personality, but I also think about somebody who has been an advocate on behalf of injury victims, for decades and decades. Even though if he was coming into my bar when I had a bar, he'd be getting ID'd. He'd be getting caught. You're not coming into this facility without an identification, young man. So welcome to the show. It's certainly great to have you. And one of the things that, as we talked, Tom, Jay is, when I say revolutionized, the work comp industry, he introduced settlements, okay, into, so you couldn't get a workers' comp. If you were injured on the job, okay, there were no such things as settlements before Jay Shor, introduced them into the industry. And it's a great story, and I know that you guys have a great friendship. Talk about that, though, because Jay is a legend in this industry.
Yeah, I think my story with Jay starts the day I found out I passed the bar exam.
Wow.
The very first court event that I ever covered was for Jay. The very first hearing I ever attended was with Jay. Frankly, the first ever case I settled was at a mediation where I was with Jay. So he's really been with me every step of the way. It was his firm that gave me my first job out of law school. So I've been doing workers' comp with Jay my whole career.
And so, ironically speaking, it's funny because, and Jay, we're going to talk about, like you're not here for a little while. But, I think about, a lot of different fields, okay? And when I think about, let's look at professional sports, right? Let's look at a young quarterback, okay? His livelihood and his future often depends on the first experience he has. If he is a bad coordinator, or if he gets into a situation where he has a series of, coordinators, mentors, if you will, that move on, okay, you'll often see that young person, become fledgling and never really get the opportunity. Having that opportunity to have Jay as a mentor and somebody to guide you through some of the most important moments, okay, had to help formulate you as a young attorney, but also in your experience right now as somebody who is very experienced.
There's absolutely no question. So I would walk into court, and you have to identify yourself for the judge when you walk in. Mm-hmm. And they'll say, are you working for Jay Shor? You better tell him I said hello. Or they'd have some inside joke that Jay and this judge had when that judge was a fledgling lawyer at some, startup law firm 20 years before, that I have to take that message back to Jay. It's a very, very small bar, workers' comp. And so that respect goes a really, really long way. And so it really gave me a jump start in my career.
I'll say this. Let me also throw one word in there, and it's the reason, aside from a legend and somebody who's unbelievable at his job, but also a gentleman. You are never going to meet a more gentleman, attorney or person than Jay Shor. And so that's why I was so excited when you said, okay, Jay's coming on the broadcast. Now, I get it. It costs you $50,000, but guess what? It's worth it.
Joe, I must tell you, as we've talked many times, an injured worker is looking for, in a lawyer, a guy who doesn't rush him when he's on the phone, explains everything to him, and shows a caring. Now, I've given Tom a nickname, And it's not very creative for a guy named Tom Wing, but I call him the Wingman.
Oh, yeah.
And if you look that up, the definition of a wingman is someone who cares and is giving to a friend or associate. Well, I'll add a client. His office is right across from mine. Time and time again, I hear him on the phone with clients explaining, never rushing, and that's why he's developed quite a reputation. And I'm proud to be part of his organization.
Well, and I'll tell you, I mean, it is exciting, no question about it. And when Tom and Roger have been doing a show for, a while now, and I am passionate about people who are passionate about what they do, okay, and who love what they do. And when we talk about an injured worker, somebody who could be in the most vulnerable position anywhere, okay, you need to have an advocate and somebody with guidance, and individuals that have that personality that can reinforce or put confidence into somebody, and at the same time you immediately need to trust them, okay, because your life is in so and that's what they exude. You know how I feel about you. We go way back. We've been doing this for a long time, and I got to know Jay I guess 5-6 years ago, okay, yeah. In a personal way. And when you're dealing with, you need to exude that trust factor, like literally immediately, because you got somebody who's panicking on the other side of the line, often doesn't want to make waves at their own expense. I don't know if I should do it. Okay, you can't walk or you can't pick your shoulder up, and I get it. Not everybody finds themselves in that situation and is comfortable, but somebody's got to protect yourself, your family, and your livelihood.
Absolutely. Joe, I find your praise a little embarrassing, but please don't stop.
I will not stop. I've had 5 days to think about it. But Tom, talk about some of the things that you learned, right away. Like, in other words, you're an impressionable young person. You get out of law school, okay? I know, obviously Roger has been in the field for a long time, and so, workers' compensation is in a sense in the family. But what are the things that, as a young, impressionable young attorney, because we all seen many young attorneys start in one place and go into a totally different field. But what were the things that you learned from day one when you're observing? And you're an inquisitive young person, that Jay, those impressions that he made on you.
Well, the thing that really comes to mind while you were asking the question is dedication. So something a lot of people don't know or may assume about lawyers is, they're off taking vacations and going to the beach, and they're cutting out of the office at 12 for 3-hour lunches. Jay is in that office every single day. Every day, on the phone with a client. He has a list of things that, okay, these are the things we have to get done today. And, if it's a client emergency, meaning the client's picked up the phone and said, look, I'm concerned about this, it's an emergency for Jay. And that dedication, that's not really, it's something you can learn, but to some extent, you're born with that.
It's interesting because I asked an attorney, okay, who's in a different field. He does personal injury, but he's in, the two of you guys are a lot alike, and real successful guys that could retire at any time they want, right? I say, where do you get the fire and the passion after so many years, like it's your first day on the job? I'll ask you that right now, Jay. What keeps that, that fire burning at the level to like Tom says, to, treat the client like it's your first day on the job?
I think in life, generally, there is a desire to be needed. We all want to be needed. And in workers' comp, there's never an end to being needed. So as long as it's fun, as long as you're enjoying it, then why stop? Now, I will tell you, Joe, the COVID pandemic caused us to go to the computers. You can be in Harrisburg at 9 o'clock in the morning, in Reading at 2 for a deposition, and back in Harrisburg at 4 o'clock for another hearing.
Right.
So it made it a little easier. Tom remembers, and so do those who work for workers' compensation firms, that we used to drive everywhere. You would be on the road to Chambersburg in the morning, and your day was pretty well shot.
Right.
But if you did a Reading, Allentown combination, you could handle that. Or an Upper Darby, Center City, you could handle that. So in a way, it's made it easier, but I don't know if we'll ever go back.
Well, it's interesting you say that because we have, even with our talk radio, so during the pandemic, we did a lot of shows on the phone, right? Before Zoom, like a couple weeks before Zoom, right? But and you're constantly stepping on yourself, because right now we look at one another, and I don't have to say Jay, I'm talking to you or Tom, but on the phone, you pretty much got to say that. You got to say the person's name, and then Zoom comes in, and we were able to start an entire organization with our labor show, literally a board of directors and everything on the on Zoom. So, and it was just a terrible tragedy, the pandemic and the after effects. We live with them every day, and so there were so many difficult things about it. No question, it devastated lives and families and businesses. However, Zoom and there are certain areas of the law, workers' comp being one of those areas, where you were unintentionally prepared. I've heard a lot of people say that. They said, well, the workers' comp bar did a great job. The trial lawyers did an incredible job at utilizing technology that was there that changed the game. And that's an example of where now, you could have all those trials or those what you call depositions where you would normally have to travel all over. You can do that in by lunchtime now.
Joe, I have to give credit to a gentleman who was my ex-partner that became the chief of the Bureau and had a lot to do with the technology that you're referring to, and that's Joseph Dorita.
Okay.
He was a judge in Allentown for some time. Then he took this position right at the time the pandemic hit, and he's done one hell of a job.
Well, I'll tell you, and so it is, and in a sense, a lot of it was by by chance. Like there are some areas I heard the immigration attorneys really got hit hard, right? A lot of that stuff was up front and personal, but having individuals like your ex-associate was so important in just making sure it was seamless. You have so criminal law. You had people that couldn't get a speedy trial, so they had some of those rules and those laws they had to kind of postpone for a bit until they had an idea of what was going on. And by the way, people were dying in the process. Yeah. So as injured workers, being able to adjust and pivot and having injured workers attorneys, very fortunate in those areas. I'd like to talk about, when I started off talking about the workers' comp settlements. Now, that is such a game changer. It changed lives. Like, it will change lives 150 years from now. Okay, I'm sure you'll be in a ton of books. Okay, I'm in a couple too, but they have like mug shots on them. It's not important right now. But if you would, let's go back to that particular thing, because it's, we talked about it before. Man, it's impressive. What was it like before a workers' compensation case could be settled?
Well, Joe, I was invited to a meeting of state legislators when I believe it was Tom Ridge that was governor, and he wanted to make some changes in comp. And so when I was called upon to speak, I said, there's basically two areas of the law where it's very difficult, almost impossible to have a settlement. One is custody, unless you can get the parents to agree, which is rare, or workers' comp. And the state legislator said to me, why can't you settle a comp case? And I said, well, unlike an auto accident where the accident occurs, the injuries are evaluated, an amount of money is set forth, an agreement is made, hands are shaken, and then a release is signed, and it's over. In workers' comp, we had this very strange system. We would have to take the amount of money that was offered, and we'd have to divide it into a weekly sum for future workers' comp benefits, and you could never settle the medical portion of the claim. It remained open. The judges would always ask the claimant, what are you going to do with the money now that your indemnity benefits have stopped? 9 times out of 10, they were buying a hot dog cart. Right. And that's the way they were going to make money. You had to do it backwards. It was ridiculous. Then the legislature seemed to be interested in what I was saying. And I said, why can't we be like an auto accident? Let's come up with a sum of money. It settles the medical. It settles the indemnity. It's over and goodbye. And they bought it and passed it. And it started in 1996. At first, there were some funny things that happened, and I remember one. We had a judge, a dear friend, I'm not going to mention his name, and these we call them CNR agreements, but they're settlements. They would come up, and he'd have to go through each one, a colloquy and a this. Do you understand this? You can never come back. And so what this judge did, he had 10 of them that day. And he lined the 10 claimants up in a semicircle with their lawyers behind them, and he ran the colloquy once for all 10. And I remember that the court reporter, after it was over, got up, and we could hear him say to the judge, Judge, how am I going to handle this? Each one needs a transcript. He said, just repeat it 10 times. And, of course, he got in trouble for that. It never happened again. But every time I see a compromise and release colloquy, as we call it, I'm very proud that I had a piece in formulating those.
It's interesting. We all have, and it sometimes happens, that moment of clarity, like that, where something makes sense. Like, even where you just see the light. Was there a moment like that where, or was it at the time, was it something that you had been thinking about for a long time? And so, or was it at that point, something recent? Was there a moment where an aha, like this is how it can be done?
Joe, the absurdity of it is even something I left out. We had to wait for the WCAB, the Workers' Comp Appeal Board, to present these settlements. So they only came to Philly, I don't know, twice, 3 times a year. So you would back up and have maybe 10, 15, 20 settlements. Sometimes, I think once when Tom was a part of things, we rented a bus and took everybody to Scranton so we could get them put through. The whole system was crazy, but it was based upon the fact that unlike an auto accident, workers' comp, the state felt that it had an interest in an injured worker continuing to receive money. And they wanted to make sure he wasn't giving it up just for the hell of it, just to get a settlement.
Right.
But as the settlements that have occurred since 1996 have changed people's lives. And you never hear someone that says, I shouldn't have done it. Maybe once in a while. But mostly they know what they're doing.
Here's an interesting point. To take it to a whole new level. Workers' compensation is such a specialized area. Now, I've talked about it 5,000 times. I have the framework as a talk radio host and somebody who, is an advocate for people who get injured on the job, because I know people like yourselves, and you guys are the individuals that stand in front of somebody who's getting abused and beat up like there's no tomorrow. However, it's such a complicated area of law that there's certifications involved in just being a workers' compensation attorney. So I would say to somebody, if you wouldn't go to a gastroenterologist, or however you say it, if you got an orthopedic problem, right? Well, because it's such a specialized area of the law, and I might be, the legalese might not be right, but for somebody who's listening at home, they have special certifications and designations. So you don't have a general practice attorney or somebody who does real estate law just dabbling in that area because it's such a specialized area of the law.
I mean, the interesting thing is I remember a conversation with a judge out in the middle of the state not that long ago mentioning that as a result of some of the COVID changes with these virtual hearings and things, this judge was seeing more attorneys that were not experienced in workers' comp.
Wow.
And it was really slowing down cases because what a lot of people don't realize is the workers' comp system, while it might seem to an injured worker to be moving rather slowly, it is lightning fast compared with any other kind of court
personal
system.
injury or something like that.
Yeah, I mean, you're in and out of a case in 9 to 12 months, fully litigated, decision on the books, and the judge has made the decision, and you're either going to get your benefits or you're not. That's unheard of in the Court of Common Pleas. I don't care what court it is, it's not going to happen. I mean, even in Philly, which is pretty fast, you're not even going to have an arbitration by then.
Joe, with the advent of settlements, and Tom can verify this, one of the questions that's asked almost at the beginning many, many times by a injured worker is, how much is my case worth?
Right.
And I'd like Tom to explain, because I've heard him do this many times and he does it quite well. How do you deal with that question?
Well, so you have to...
Hold on. He calls me up and I'm like, listen, Tom, I'm in the middle of, a basketball game. I'm sorry. Go ahead, Tom. Just kidding.
So you have to take a look. When you have a workers' comp claim, there's a lot of different benefits that somebody can potentially be receiving or is going to need to receive into the future. So you have wage loss benefits, medical benefits, and then for more specialized claims like specific loss benefits or even death benefits or funeral benefits. And so when you're dealing with how much is a case worth, the question is all about risk to the injured worker as to the uncertainty that could happen to them in the future, and the risk to the insurance carrier that will ultimately cut the check, that they'll have to cut a check that's much larger. And so it's balancing the costs of those different benefits with the potential for a bad outcome. And so the value can kind of ebb and flow depending on the status of the injured worker's treatment or their or whether or not they're being paid wages, but certainly wages and medical are the two big factors.
When is that conversation? When is it? I know that conversation doesn't happen at day one, but when does that discussion of settlement actually, come up? Like after IMEs, like how long? It's a 12-month on average litigation process, but at what point during that process is typically the discussion about settlement come up?
It depends. So
I would ask Tom to differentiate, I know he does, between what we call a claim petition and a termination or suspension, because they're different. Where there's a claim petition, and Tom can talk about this, you're fighting for benefits. On a termination petition, your client already has benefits. And it affects value. Tom, go ahead and talk about that.
Yeah, sure. So in a termination or suspension petition where the injured worker is receiving benefits and an insurance company is trying to stop them, they've already admitted to the compensability of the claim. They have to pay benefits. They're asking permission from a court to stop them. So typically those cases have a little bit more value than the ones where nothing has been admitted in a claim petition, where they've only admitted to the medical portion of the claim, and typically it's something that's under-described. You have a guy that fell off of a 10-foot scaffolding and they diagnosed it as a bruise at the insurance company. So
it's a mild strain.
Right, exactly.
Yeah.
And we see that all the time. But to answer your question, Joe, it depends on the case when the client's going to want to have that conversation about settlement. The best time to value a case, though, is when all the evidence is on the table. So it's going to be after you get the independent medical examination. I say independent in air quotes.
Right, of course. And that's what point does that typically come? It's like 6-9 months down the road?
It depends on the injury. So Jay touched on it. Those termination suspension petitions are typically happening as a result of an IME.
Right.
Yeah, and okay. So, and when we say, let's talk about the IME for a second, the so-called IME, independent medical exam. How does somebody, I've heard these discussions probably in the past with both of you at one point of time, but I get it. I can say this, but it's tongue in cheek when you say independent, because we know it's. How does a medical provider, okay, who hasn't seen an injured worker ever, okay, hold on, I want to get my good side here, and I just. I got you. Oh, you got it. Okay, all right, that's important. They have we're taking pictures in the studio. And you have what do you call it when you Photoshop? Right?
Well, we got to get you that ring light, so we get all of the good
resonate
stuff.
exactly,
yeah, exactly.
But somebody an independent medical exam where a doctor or medical provider examines somebody for 6 minutes, okay, after they've had treatment for months and months and months, and makes an evaluation, and how does that even credible? Like, I mean. You would think,
Joe, you're talking about doctors, usually orthopedic doctors, that are board certified, that have good reputations. Some of them are well known among the judges. And they do it over and over again. And quite frankly, nothing against them. They can earn all the money they want. They earn a lot of money. And so many times in a deposition, Tom or I will say, sir, how much did you charge for this deposition? How much did you charge for the exam? To plant a little seed with the judge that this guy's a hired gun. But it's not that easy, because it becomes our doctor versus their doctor, and a judge sits back and tries to decide which one he believes better.
He's going to evaluate the situation.
It's tough, and we've lost cases. And won many times.
How often does the treating doctor, which you say is your doctor, but it's the client's doctor who's been treating them for a long time, but how often does it, and how much treatment? Let's go. This is just, obviously we're being hypothetical, but let's compare it. How often at the time of an IME, which isn't 2 weeks in, okay, how often has typically, just the general, that their treating doctor treat them, the one who's given their side of the story, how long can that be? Months and months, and I can.
Oh yeah, I mean, typically we'll see a person isn't sent for an IME usually at least until 90 days are up in the claim. In that first 90 days, generally no IME is scheduled.
Right.
And so they're going to be with that treating physician who's going to see them right after the injury, usually right after an emergency room or something like that. And they're going to treat them 3, 4, 5, 6 months, and then they're going to have that 6-minute exam. And you know what's funny about those exams? I've cross-examined these doctors, and I ask them to walk me through the examination, because a lot of times they'll generate this report, and Jay will tell you they're 6, 7, 8 pages long. There's no way they did all this stuff in 6 minutes. And so I asked them to describe each one of these tests and walk me through how they do it. And that's another way you can kind of show, because they churn out dozens. Some of these doctors do dozens of these.
Oh, I've heard, there are some situations where there's a template, some kind of like, a template that they fill in. But I heard that from a doctor, not that somebody who says, no, I write mine freehand or whatever. When I think about this, obviously, you look at individuals that try to advocate for themselves, and they end up in a pretzel where they don't want to make waves or whatever. It's like, they've been working for the company for 10 years. Even if the company stands on their side, I witnessed. The owner of the company witnessed the injury, and still the insurance company will oppose that. There have been a number of stories that I've heard like that literally can be confusing. And I guess in a sense it's a protocol. Let's do this. Let's take a short break. We're going to have more from the McMenamin Wing Show and our guest Jay Shor in just a minute. My God. Welcome back to the McMenamin Wing Show. Shout out to Tyler in our producer's booth. We're We're here with Jay Shor, legendary workers' compensation attorney. And
you got the broken chair.
I just went down. But hold on for one second.
Now, for the people that can't see this, Joe Doc is now, he's approximately 3.5 feet tall now because his chair is collapsed into the floor.
The funny thing is, I realized that after 7 years that if you hit the button on the side, the little lever there, that's when you go down. So it may not be the chair, it just might be me. But yeah, it's so. Having said that, we're talking about independent, quote unquote, medical exams. I do want to ask you one thing, okay? I do get a kick. It's funny. Jay just said something. He said, "Listen, it's just unfair. These are not really independent medical exams. They're more defense medical exams, and a title means something." It's awesome to be able to sit. We got to do something about that. It's pretty cool being able to sit across from somebody who could just say, you know what, let's do something about it. In about a month from now, Tom, our next show might not be independent medical exams. Jay, you wanted to kind of stay on that topic a bit because obviously, that's a difficult area for somebody. They get treated often. I've heard you're 2 minutes late for the appointment. They, sometimes they'll exit, they'll terminate somebody's appointment and they'll have issues.
But the attorneys like Tom and I get to know these doctors. They're not new. They're doing hundreds of these over and over again, and they have a style the way they do it. One of the things that I've been offended by over the years is when a doctor says, your client exaggerated his symptoms, symptom magnification. And I kept thinking when I do the deposition, how can I get across to him that I don't like that term? And I came up with something that I thought was pretty good. And I would say, doctor, you use the term symptom magnification. Are you saying that my client has symptoms and exaggerates them, or are you saying my client does not have any symptoms at all? And that works because he has to say, well, I'm sure he has symptoms, but I think when he moves his arm and he groans, well, that's all good to get on the record. The groaning, the moving the arm. If he says, listen, this guy has no symptoms and he's making it all up, that's good too, because that's
outrageous,
yeah.
Right? Well, it's interesting that point there is that's really kind of what I was getting at. So, in other words, having an aha moment after years, okay? And I've had them I've had them, obviously not in this area, but or if it's a show or something like that, like when I'm exhausted, I'm just about to lay down, and I'm like, now I got to run down to the basement and get it on my computer. But I'd imagine, like, what is that moment like when all of a sudden, and you may be at lunch and sitting there, time out, guys, I got to speak into my eye memos or whatever. But that type of a cross examination, I got it when you were saying it. Like it's a magnification of symptoms. Yeah. Okay, well then you're saying he's got symptoms, right? And then at the same time, you're not saying, you just said he had symptoms. Now you're saying he doesn't. He's not. I mean, what's that moment like? When
I can tell you that Tom has learned to do cross-examination very well. And I'm sure he's had some moments that he was very proud of. But, you don't need much. And if you're going to try to match wits with a doctor on medicine, most of the time you're going to lose. What you need is a little bit of something here, a little bit there, so when the brief's written, you can say things. For an example, if a guy falls off a roof and hits a cement, you say to the doctor, you agree, do you not, that my client suffered a significant trauma? Oh, yeah. Well, that's something. You got something there to start. I mean, Tom, you talk about it too, because you cross-examine a lot of doctors.
Yeah, I mean, one comes to mind as you're describing this. I represented a woman who slipped and fell outside of one of these walk-in freezers. And she struck her wrist on some metal thing. I think it was a card or something. This was a couple years ago. And she went to the emergency room, and the nurse practitioner that evaluated her in the emergency room noticed a bruise and put it in the ER record in bold. And what do you know? When the IME doctor examined her, There was nothing wrong with this lady. And mind you, this woman needed to have surgery. But the IME doctor said, no, she's good to go. Go back to work, fully recovered. But didn't diagnose a bruise. Said she probably had a shoulder strain, her back was a little sore, fully recovered. And the aha moment in that deposition was when I was asking the doctor if he reviewed all of the records and if he had some reason to dispute the fact that there was a bruise that he had failed to diagnose or failed to notice. And he wanted to have a fight with me about that. And then it turned out he knew the doctor and worked with the doctor that the nurse practitioner that had seen my client in the emergency room. And it blew up that deposition. This case was pending in front of a very conservative judge, pretty far out in the state from where we're sitting here in Bala Cynwyd today. And you're not known to win a lot of cases as a claimant in front of this judge. We won that entire case. And I believe to this day that the reason we won that case was just from the doctor trying to argue with me about whether or not my client had a bruise, which, by the way, would have been fully recovered by the time this doctor saw her was a bruise.
You know, what's interesting was this is really fascinating to me because, you know, as a lay person, I can have the basic discussion. Hey, what should somebody do at the point of injury and all that? But one of the things I can't, you know, obviously, you know, and this takes a real specialist, but Jay, when you got into workers' comp and you know, you started practicing, did you have a mentor? Did somebody, even if it wasn't in workers' comp? I asked you that question because I can imagine, okay, this is an area of unbelievable complexity that you guys have probably talked about for decades, and that is landmines attorneys on both sides could walk into. You know what I mean? Like, in other words, you know, you just mentioned, Jay, you know, you in a sense, you know what you don't know. Like, you're not a doctor, you know the medical, but what not to walk into. And as a young attorney, okay, and we've all made, in a sense, you know, a mistake where okay, you live and you learn from that mistake. Or if you're lucky, you see somebody else make it and say, I'm not going to do that. Those depositions and cross-examining, you know, what from a young person, okay? And I've always wondered what it's like when somebody, if I'm an injured worker, I want an attorney who's got experience. I want to be able to look across the table and say, okay, this woman or this man has, and I get a lot of young attorneys work defense, right? Okay, because that's where you cut your teeth. But because who's going to hire a 26-year-old to go to court with them? Okay, no matter if they were number one in their legal class or not. But stepping on those landmines and learning, you know, and making those mistakes, or having somebody help you avoid those mistakes, and really, you know, that process, you know, from an early age. Did anybody mentor you, or did you have to learn?
Well, Joe,
trial
don't
by
forget,
fire?
I spent 8 years as the chief of trials at the Montgomery County District Attorney's Office.
Okay.
So in that role, I watched a lot of great lawyers. And workers' comp in that regard is no different. If you think that you're something special to start out, you're going to end up in bad news territory. You have to realize that you're new, that you don't know a lot. I can remember the first case I ever had was before a judge in Philadelphia, and it was a divorce or a custody, I forget. And I showed up, and a case got called, and the judge looked down and said, are you ready to start, Mr. Shor? And I said, Judge, you're not going to believe this. I left my file home. Well, he went off the record, and he said to me, get in your car. This was in Center City. I lived in the Northeast. Go get the file and come on back. And I never forgot a file again. So there's things that I'm sure Ton remembers from getting to be a lawyer. They're all the same. You need integrity. You need honesty. You have to know what you're doing. And that means studying your case before. Don't walk in cold. Know your case.
You know, and it has just dawned on me, okay, in workers' comp, you're going before a judge. You're not going before a jury, which means in criminal law, sometimes you get the choice. No one ever picks the judge; they all pick the jury, right? So you're going in there with somebody who's you're pleading your case in front of an expert. Okay, there's nothing they haven't seen. Is that expert, by the way, is always the second choice when it comes to a criminal trial, because you're not it's not 12 peers, okay? I mean, the legal peers may be yours, but they're not the peer of the injured worker, so the pressure's on from day one. Like, this individual knows the business, understands. How much is that your personality, but also your demeanor, especially when you're in front of a judge, okay? And you're always in front of a judge. And operating in front of that individual as a judge, as an expert, which, by the way, as we said just now, in criminal court, everybody tries to avoid that like the plague, right? They want the jury of the peers. What's you were in the court system. What's the difference in that presentation when you're in front of a judge, rather than if you had to be in front of a jury?
Well, quickly. Jurors want to be entertained. They watch television. They want the Perry Mason minute.
Right.
They want something explosive. They want at least to hear a continuing story. So when I was learning to present an opening argument, a closing argument, you simply try to give a story that they can follow. Don't make it too complicated. Don't make it too long. And you're more successful that way. But in comp, I think Tom can talk about what it takes. There's not many times that we argue before a court or a judge at the end of a case. Once in a while, but not often. And Tom, what do you think about what you've learned to present and not present?
Yeah, I think, and when you were talking about telling the story but keeping it short, I recently got hustled along a little bit by a judge you and I both know very well, has been on the bench a long time up in Harrisburg, for not moving quickly enough for testimony. Right. So, as you alluded to, these judges are very experienced. They know the system. They want the facts. But you still have to present your client in a persuasive way. As Jay mentioned, in these cases, you're not winning your case on an argument, typically. It's how you present your witnesses. It's how you cross-examine the other side's experts. That's where your case wins.
I've never talked about this. I've never gone down this road, and I find it incredibly interesting. Judges in your world, they know protocol, okay? And are they real sticklers for it? Like, that's why. Is it easy to see somebody who's just dabbling and helping a buddy out? I really am a landlord-tenant attorney, and I'm going to help. Do they stick out like a sore thumb?
Not only can you tell who is new or who doesn't do this all the time, you can tell if you're sitting, some of these courts before COVID, you would go in person. And as Jay mentioned, when he was talking about the CNRs, the 10 guys lined up, you're in a courtroom with maybe 25 other cases. So you're watching the other cases go before yours. You know who didn't even look at their case file before they walked in. It is glaringly obvious if someone knows what they're doing in workers' comp.
And it's disrespectful to the judge.
Oh, yeah.
You're supposed to be prepared. Joe, you talked about clients and what they do and what they want. One of the things that you have to learn as a new attorney is, believe it or not, how much to ask for when you're trying to settle a case.
Oh, yeah.
And Tom knows this story, but we learned that you have to leave a lot of room to negotiate down. And so in a standard case, most lawyers will ask for 5 times comp, a year's worth of comp, sometimes 6, 7, depending on how serious the injury is. So they have plenty of room
to wiggle down. I can remember early in my career one time, and I've asked many lawyers, and I think I'm the only one this ever happened to. I decided to ask the adjuster on the phone. There was no tech like, emails and TikTok, and this was on the phone. And the adjuster said, "How much do you want for the case?" And I had given this a lot of thought. I said, "I'll tell you what, give me $62,500. Knowing that I left plenty of room. There's a pause on the phone,
And the adjuster says, okay. And I almost had a heart attack because the one thing you never want to happen is to hear an adjuster say on your first offer, okay.
It could have been
and
a lot
it never
more.
happened again, but I should have asked in that case for probably $100,000. But I think it would have ended up the same anyhow.
Well, that brings up an interesting point. When you do have a settlement offer, okay, and a lot of times, when you talk to a personal injury attorney, first of all, I'm a horrible negotiator. I'm always giving the house away. Like when we were in our nightclub business, my brother was the tough one. I was, and so I would always, feel bad. I'm just not, and so when I think about negotiating, it gives me, it gives me anxiety. And I say that I can't imagine what it's like. I'm negotiating Friday night, okay, at a night spot, right, where we average a specific amount, and I'm blah blah blah, and I might give somebody a break, whatever, but it's not somebody's life. It's not their livelihood. Even though my brother, if you talk to him, we have to pay bills too. But the point I'm making is now you get a settlement offer. Now you got to go. Now you're going to sit down with somebody, okay, and you're going to either tell them to or give them advice. That's a major responsibility on whether that this is their life on the line. Okay, and I have had the conversation with personal injury attorneys when they get an offer of $1.5 million and they know it can be a lot more for something, right? Going back to, but they also know the risk. I'm just saying, work comp, settlements aren't typically that. But the point is, what type of responsibility is that? You're giving somebody, advice, and you have done this so many times. You invented it, okay, Jay, but. Talk about when you get an offer and advising the client whether they should take it or not, especially if your advice is, it sounds good, but it's not enough.
Before we start, Tom, why don't you describe and explain what this thing is called a mediation and how we participate in that?
Sure. So a lot of times the way a case will settle is you get to go to a mediation. Which is a judge that's not assigned to the case is going to sit down with the parties and help them come to a resolution. And a lot of times we'll make that initial demand that 5, 6, 7 years Jay was talking about ahead of time so that the adjuster and the insurance carrier and the defense lawyer can have a conversation about what the claim is worth, get some authority together and be prepared for that mediation. And so that first offer routinely will come at that mediation.
Okay. But going back to the client and you're giving advice on, let's just say that mediation that you walk out of there and you're not happy with it, right? And you think that, and maybe this may be more for a conversation for a personal injury situation, but either way, you have to advise that individual based on your own personal experience and opinion. Talk about that responsibility, especially if it's no. Like, in other words, and now they're risking, okay, if they don't take it, something could happen down the road. Talk about that responsibility.
Well, I do this, and I know Tom does as well, and he can join in on this thought. But you should have your client prepared for the mediation. In other words, look, I think we can get this defense attorney and the adjuster and the insurance company up to 3, maybe 3.5 years full comp. And you work it out and give them the number. No shame if we take 2 years. No shame if we get 3.5.
So you have a plan going in.
Right. Don't forget, client, that we're partners. I get 20 cents, you get $1. So remind them of that. Remind them further, as Tom always does, that your settlement is tax-free in workers' comp. So it's valuable money. So the client knows what you're shooting for.
Got you.
And if we don't get there, you say, hey, we can go forward with your case. We're not getting there today. But most of the time, we get there if we don't over-exaggerate the value. Tom?
Yeah, I would agree. And I think particularly in the context of mediation, when you're that mediation is a great experience for a client. So they can sit down and get a perspective that's not their lawyer. So if they're second guessing, or in this day and age, they're Googling their questions, which is a total nightmare a lot of times. But that can give a client a peace of mind of knowing, okay, this impartial judge is saying the same thing my lawyer is saying. And sometimes that's really, really helpful. So even if the case doesn't settle, it can give the injured worker a little bit more perspective on where they sit in their claim and what their risks are.
So you mentioned the 20 cents, right? And what's important, and I always like to bring this up for our listeners. It's so important. I'd say that if I had to pay Jay Shor out of my pocket to represent me and walk in, I'd have to mortgage my house. But fortunately for me, there's something called the contingency fee agreement, which I could never afford Jay Shor if I had to pay him an hourly rate, okay? And I'll throw you in there too, Tom Wing. But there's something called the contingency fee, which means that I can get great attorneys, great legal representation, okay? And it doesn't immediately come out. It never comes out of my pocket. Now, there's a process in workers' comp. Talk about it, if you would, Jay.
Yeah. First of all, unlike personal injury, we're limited to 20% by law.
That's a bargain.
Yeah. You can't go to the billboard guys, who I know them all. They're all friends of mine, and say, look, that guy charged me 30%, and I'm glad I'm with you because you're 20. No, that doesn't happen. It can't happen. It's against the law. In personal injury, you could pay a third, you could pay 40. I've heard stories even higher. But that's taken care of. So the client knows that. Sometimes they forget, because what will happen, and we called it a termination, where the guy's on benefits and you do something that you're entitled to the 20% ongoing as he's collecting, all of a sudden his check is reduced by 20%. And he calls up and says, hey, what the hell's going on here? Well, the 20% is to represent you.
Right.
And
sometimes, by the way, that doesn't happen right away. You might do what they call babysit a case for
a long time.
Long time.
Sometimes you don't get any fee until that settlement.
Right.
So you do a lot for a client. And quite frankly, we don't think about that. We have clients that we have never gotten a fee and we'll get it at settlement. We have other clients that we've gotten it with the beginning of a termination petition because we'd had to go into court and we asked the court to award that. A claim petition, you don't get paid.
Yeah.
A claim petition's a year, a little longer maybe, and you don't earn a dime. And not only do you not earn a dime, Joe, but that doctor's deposition that you have to take on behalf of your client is going to cost you $3,000, $4,000, $5,000.
And that comes out of your pocket, never the client.
Well, you get it back.
You get it back.
You win.
If you win.
If you lose,
you win.
It's the cost of doing business. Tom, go ahead.
Yeah, so Jay kind of hit the nail on the head. The way the contingency fee works is we assume all the risk of not recovering anything. There's no risk to the injured worker. And then if we win or we keep their benefits on, the 20% attaches and we'll front all the costs of litigation. We'll collect those costs at the end of the case if we're successful.
We got about a minute, maybe, what do we got? 2 minutes left. I'd like to ask, Jay, obviously as successful as you've been and throughout your career, and we talked about what keeps you passionate, but when a client calls, what can they expect? In other words, in the communications and somebody at your stature, sometimes you could just call it in if you want to get somebody else to answer the phone but that's not what makes you who you are.
No. Joe, it's changing. And I want Tom to talk about this because he lived under the old way and he's very attuned to the new way. Technology has helped in this whole process. It's quicker. It's cleaner. The clients understand it better. Now, you'll never do away with the phone call where the client feels that he's talking to somebody that knows what he's talking about in workers' comp, and it makes them feel good. That can never be replaced.
Mm-hmm.
Tom?
Yeah, certainly at this juncture, most effective lawyers give out their cell phone number, and that's what we do in our office. You have access to your lawyer 24/7, and the clients want that. They want to be able to talk to their lawyer when they need them.
Absolutely. Well, gentlemen, this has been the fastest hour in radio. Jay Shor, it's been awesome having you on the program, and we're going to have you on a lot more now. It's certainly was looking forward to it. You did not disappoint, my friend.
Thank you, Joe.
Tom Wing, great show, and contact information for our listeners, my friend.
Sure, McMenamin Wing. We have 2 offices, one in Philadelphia, one in Willow Grove, 215-609-4183.
Well, it's been an awesome show. Shout out to Tyler, our producer, and our photographer. Who's my man here?
That's Matt.
Matt in the house. Make sure you get, again, Matt, we're going to be screening them pictures. I want to thank everybody for tuning into the McMenamin Wing Show. Of course, we want to thank Jay Shor, legendary workers' compensation attorney. And we can't wait to have you on again, Jay. And shout out to Roger McMenamin and of course, Tom Wing, our co-host. On behalf of everybody, I'm Joe Doc. Thanks for listening, everybody.